Our guest today is attorney Ethel Mitchell of Wills and Trust LLC. Attorney Mitchell is also the host of a weekly radio program, Law Talk with Ethel Mitchell. Welcome, Attorney Mitchell.
Thank you very much for having me.
You're
Thank
welcome. You know, normally people say, is there a doctor in the house? But
you.
this evening we can say, is there a lawyer in the house?
Very
And we
good.
definitely have one here with us. So
Yes.
thank you again for taking time out of your schedule to join us
Well, thank you.
and share some vital information. So let's talk about your law experience. How
Okay.
did it start?
Well, what I want to start with is what I do right now is strictly wills and trusts
Okay.
and estate planning. That's all. Because I've had a long career. I've done a lot of different things. I went to Fisk University and Columbia Law School. I've worked in the Virgin Islands in St. Thomas for many years. I've been to Ghana. I came to D.C. to work with the Congressional Black Caucus Foundation.
Awesome.
And then I opened my own office and decided I would only do wills, trust, and estate planning
Interesting.
because I love families. I love protecting property.
Okay.
I love helping people to contribute and make sure that their intergenerational wealth is something that I'm very passionate about.
Very important.
And supporting institutions, schools, churches, things that do good in our community.
Right.
But a lot of people in our community don't know how to do that.
And let's talk about that. When you say
That's-
not knowing how.
It's
yeah,
critical.
because you're helping to facilitate a very, it could be an intense conversation for some families.
Oh, definitely.
Right? It's
definitely.
not
Every
always
day.
easy.
It's not easy.
To talk about property, what you're leaving, and
Yes.
wills. So where should they start, or how should they start?
Well, when somebody
the
calls my
process?
office, I send them a client information form, even before they walk in the office. And so when they walk in, they're bringing me a sheet that has name, address, phone number, names of all their children, names of their spouses, and their addresses,
Right.
who their intended beneficiaries are,
Okay.
what their assets are approximately, and what thoughts they have about distributing their assets.
Absolutely.
And are there any particular concerns? Do you have a disabled child? Do you have a person who has a drug addiction or alcohol or gambling addiction? But you want to take care of them, but you know if you give them money,
beforehand,
it's gone.
right?
It's gone.
Yeah.
So when you walk in, I'm able to focus immediately on your particular situation. We're not talking in theory.
Right.
We're not talking about what could be for somebody else. I like to talk because everybody's unique.
And it's a tailored
I really
experience,
believe
yeah.
that. I really believe it. I don't believe in cookie cutter wills. I don't believe that you can just go to Staples or online
Get
and
the template.
get, a will that works. The same will doesn't work for everybody.
Right.
And often people don't know what the wills are really saying, and so they don't know what they're doing.
Okay.
And unfortunately, you can't fix it.
Right.
Once the person is dead, it's
and,
done.
And,
you know what
and
I
you
mean?
mentioned like unique
So-
experiences for families. So my question would be, would you recommend that families have this talk
Not
in an open
necessarily.
a setting where
No,
everyone kind of
no,
has an idea of what's going
no,
on?
No.
Okay.
I'm not one of these lawyers that says you have to talk to your family about everything. I do not. Because what I find is it's better for you to know what you want to do and then talk it out.
Okay.
You know your family better than I will ever know them.
Right.
So you decide if you want to talk to your family or not. I tell people, don't tell them what's in the will. One, it's not your business.
Right.
And two, it's your stuff. You might change your mind.
That is true.
Okay, so you don't want to do a will. Tell your children I'm doing ABC, and then
They're
the
planning
will
their
comes
lives
up,
accordingly.
And plus, what we find is that if I tell you that I'm going to leave you ABC, and then, your sister finds out, your sister may want B, and so now all of a sudden I'm getting pressure
That's right.
from your sister
And the
to
stress.
change what I
Yes.
want to do.
Right.
You see what I mean?
Right.
And a lot of times people are weak or elderly. You don't want to be bothered with all of that.
That's right.
You don't want to be bothered
Yeah,
with all
absolutely
that.
right. And so, in starting the process as well, what are the 3 most important documents that
3
every
documents.
adult should
A
have?
power of attorney,
Okay.
a medical directive, and a last will and testament.
Okay, and break those down for
Okay,
me.
everybody can go out of here, have a car accident, have a stroke, have a heart attack, whatever it is, any adult. And contrary to popular belief, unless you have appointed somebody in writing to have your power of attorney to act for you.
Right.
There's nobody that can sign your checks. There's
Really?
nobody that can pay your bills. There's nobody that can call up the credit card company and say, hey, my mom is sick, send me the bill and I'll pay it for her. You've got to have in writing a power of attorney.
Interesting.
Even spouses think that they can do it for each
that.
other. No, there's nothing that says
automatic.
just by virtue of marriage, you have the right to sign on your spouse's bank account. If your name's not on that bank account, you can't do it.
Have no access.
There's no access. The banks are not supposed to let you do it. They do, but they're not supposed to. I've had spouses call me from hospitals saying the employer won't even tell them what kind of insurance they have because there's no power of attorney.
Wow.
I've had children call me and say, my mother had a stroke, and we know she has long-term care insurance, but the insurance company won't talk to me because there's no power of attorney.
Right.
So the power of attorney is really an important document.
Okay.
And if a lawyer does it for you, we can make it so it's not effective until or unless two doctors say that you have lost the ability to make decisions.
On your own.
On your own.
Okay.
So it's important, especially for elderly people, to understand
Absolutely.
they're not giving up their power.
Right.
They can still do what they want to do. You can revoke the power of attorney if you
At
don't like
any
what somebody's
time.
doing it, at any time. And you can make it what we call springing, where it's not effective until you become incapacitated.
Wow.
Okay.
So power of attorney, the second
Power of
one.
attorney. The second one is a medical directive.
Okay.
Again, that says two different things. One, this is a person the doctors can talk to. They can share your health information is private.
Exactly.
So even your spouse is not supposed to know what's going on with you with your health unless you say it's okay.
Prescriptions and
And what kind of treatment.
Right.
And making decisions for you about that treatment. It's important to have in writing where you designate somebody and you say, this person, it can be anybody. It could be your sister, your mother, your brother, your good friend. But you've said, this is the person I want to make decisions for me if I can't make them myself.
On your own. Okay.
It's equally important, I think, that you say if you want to be on life support or not.
Very good point.
You don't want somebody else having to make that decision. You need to make that decision yourself, and you can say yes or no.
Right.
You can say I want a feeding tube or I don't.
Okay.
You can say do everything to keep me alive
And
or
then
just let me go. You make those decisions again in writing. So that's the second one, the medical directive.
Right.
The last will and testament says when I die, the stuff I've accumulated, my house, my bank account,
The minks and the furs.
all the yes, the minks and the furs and the jewelry and all those things. This is what I want done with them.
Right.
This is who's to get my stuff. Okay, and it also says who's going to be in charge. And in every family, that's an important thing for you to say who's in charge, because when you don't have a will or you don't have a trust, everybody has almost equal rights on certain levels of relationships. And a lot of times we find, I've actually seen houses lost because they couldn't agree on who's going to be in charge.
Wow.
People fighting about who's even in charge, you see what I mean? Much less how it's supposed to go.
And while you're fighting, the house
is, nobody's paying the taxes, nobody's paying the insurance and all like that. And then the law says how your property is distributed if you haven't said so. Every state has a law called the law of intestacy. And that governs how your property is to be distributed if you have not made a will.
Okay.
Okay?
Okay.
And so if you want somebody to receive your assets, you have to say so. You have to say, this is who I want to get my stuff.
So let me ask you this, Attorney
Sure.
Mitchell. So in a case that you do not establish a point person, or you haven't written it out, where are your items actually going? Who receives
The law
it? The
determines
government?
that. The law says if you are not married
You're single.
and you don't have any children, but you have a parent alive, then your parents get all your stuff.
Okay.
Okay. If you have children, then your children have first rights.
First rights.
If you are married and have children, then your spouse and your children inherit.
Divide what's
Yes, and what
belongs
people
to
don't
you.
understand is your spouse does not automatically have control over what your children get. So let's say you have $100,000 in a life insurance policy, okay? And you've got a spouse and you've got 2 children, and you don't have a will.
Right.
Then that policy goes into your estate, okay? Then the state says, in some states the spouse gets 1/3 and the children get 2/3.
Okay.
In some you know, it really varies by state.
Right.
So then you have $100,000. Your spouse will get $50,000. That's after going through probate. It's going to take them about a year to get it. Okay. But the other $50,000 is going to be in a court-appointed guardian who's going to have access to that money, regardless of what the spouse says. And they have to report everything to the court. You have to go to get permission to get the money from the court, even the guardian. And it all could be avoided by having a will that says, this is who I want to be in charge. This is how I want it to be done. And of course, when you have minor children, we often recommend a trust, and that's a whole nother thing.
That's another discussion.
Yeah.
And so, you know, with all this information, and you've given so much in just a couple of minutes, you know, of just sitting here, why aren't we talking about this and process? And why aren't, I think, churches getting involved and having these seminars where this knowledge is shared?
This is what I do. Every Saturday morning, you can tune in and you can call me up and ask me questions about this. I go talking to churches. I do a lot of speaking at churches, and I don't charge for it because I think it's so important. I speak at, like 2 weeks ago, I was at LexisNexis. They have an employee group, and they said, please come talk to us about this stuff, you know? And so I did, and I have a whole PowerPoint presentation. I've done presentations for the AKAs, the Deltas, the Links, you know, because we need to know this stuff.
We do.
And people are so concerned with gentrification. Well, one of the ways in which you can deal with gentrification is to make sure any elder that you have has a will. Any older person that you have that expects you to take care of them, they need to make sure. You can tell them, I said that they have to give, the Attorney Mitchell said, Mama, if you want me to sign your checks, if you want me to go get your medicine, you got to give me a power of attorney.
Wow. Okay.
You got to give me a medical directive. And you got to have a lawyer do a will for me, a will that says, I get this, or whoever, however you want it to go.
Absolutely.
You gotta say it.
And we're going to continue this dialogue.
Okay.
Everyone, will be right back. Amazing knowledge that's being shared. So stay tuned. We'll be right back.
Meet Henry and Wendy Jones. They have 2 children, Alex, who's 12, and Brianna, who's 8 years old. They live in a suburb just outside of Boston. They have a home, some money in the bank, and a small retirement plan. Like most people, they have a mortgage, car loans, some credit card debt, and Wendy's student loan. Wendy is worried about the family's future because her best friend Mary's husband just died unexpectedly without leaving a will or any kind of estate plan. Many of the assets were solely in her husband's name, leaving his wife Mary dealing with the burden and expense of the probate court. Without his income, Mary told Wendy she is unable to keep up with the bills and is now selling the family home. Wendy doesn't want this to happen to her or to her kids, and informs Henry that they must do something about it now. They scheduled a meeting with an estate planning attorney. At the meeting, he was able to show Wendy and Henry how to prevent what had happened to Mary from happening to them. He also raised issues that Henry and Wendy had never considered, like, do they have healthcare proxies? What if Wendy was in an accident and not able to make her own decisions? Would Henry be able to make medical decisions on her behalf? Have they set up durable powers of attorney so that Henry would be able to refinance the house to pay the medical bills? What if both of them died in an accident? Is it spelled out in their will who would be the guardian of Alex and Brianna? And how a revocable family trust will manage the money for their minor children and designate at what ages they should receive it. He also discussed how everything could be done without a prolonged and expensive court involvement. As part of an estate plan, they incorporated life insurance policies as a way to deal with the debt and loss of income. Henry and Wendy now rest easy knowing that they've protected each other if one of them is ill or dies, and have protected their children through the trust, should something happen to both of them. Their estate planning attorney made the process easy to understand. They feel more confident and in control of their family's future.
All right, welcome back, everyone. We're here with Attorney Mitchell, and so we've been having this amazing conversation, and I definitely have more questions to ask. So let's continue our dialogue.
Okay.
And one of the questions that I had before going to break, and just, you have the radio show, you're providing this great information. I will say there are a number of lawyers, I think, in the area that are trying to put it out there, and you guys are such a blessing, I think, no problem, the entire community. But what else can we do to be proactive, would you say, in this whole process?
You want to make sure that every family encourages all of their adults, but particularly when somebody is sick. If your mother or father has had or your sister or your brother, your uncle, whoever it might be, if they have already had a stroke or a heart attack, or they've been diagnosed with cancer, even if they're in remission, we often find that people who are going through things like that, they want to do these documents.
Absolutely.
But their loved ones are uncomfortable raising the question.
Right.
So some kind of way we have to make it okay, you know, to say, mother, dad, uncle, aunt, sister, brother, I want you to go to a lawyer, and we need to get your business affairs in order. And that's older people, especially in that 70 to 90-year-old,
that bracket,
they like to have their business in order. They really do. So if you allow them to do that, or you make it easy for them to do that, often they will.
Okay.
Now, unless they are, one, they have to do it while they're competent to do it.
Right.
You cannot wait until somebody has
Dementia.
lost the ability to know what is what. Two, a lot of times I'll say to them, I'm not going to talk in front of your family. It's just you tell me what you want. Okay. Because you're my client, and then I'm going to put down what you want. So most of the time they're okay with the family, or people don't really bring their whole families. They bring like one or two people. And I think that's suitable. And I leave it up to them as to how much they want to share or not. Absolutely. That's entirely their business. Yeah. Okay. But it's got to become, particularly, we'll get back to gentrification. I was going to. Yeah. Mama wants you to keep this house. You know the house is worth $600,000, if not $1 million. I've had people come in and their houses are now worth $1 million. Okay. They want you to be able to keep the house. Absolutely. Tell them, in order for us to keep the house, Ma, you got to have a will. You have to have a trust. Or, you got to talk to a lawyer that does this kind of work. So number one, we don't spend a whole lot of money and time going through probate, trying to get from your name to the next name. It over. Okay? Right. You want to make sure that you're working with a lawyer that does this kind of work, because people try to short circuit it, and they end up costing the family a whole lot more money. Okay. I've had so many wills that were done online, takes thousands and thousands of dollars and time and years and it's to fix. Incorrect. Right. Okay, that a simple discussion with a lawyer and let them do it right could have avoided. Saved a lot of time. Yeah. Another thing that's really important, Crystal, is deeds. Bring your deed to a lawyer and let us look at it. If your mother comes to me and says, Crystal's my only child, right? So when I die, I want her to have my house. I can probably do something to her deed while she's alive, record it so that when she dies, the house goes straight to you. Okay. There's a reason why you don't want her to put your name on the house right now. And why is that? There's a tax reason. If she bought the house for $20,000 and the house is now worth $600,000, if she gives you, because IRS thinks if she puts your name on the house, she just gave you $300,000.
Okay.
Okay?
Mm-hmm.
So instead of that, if you wait until she dies
Mm-hmm.
and gets the house, you get what we call a step up in basis, meaning that her basis is 20,000, but when she died, the house is worth 600,000.
Right.
So your basis is now 600,000. So if you go to sell it, that you don't pay capital gains between the 600,000
Wow.
at that it was. But if she gives it to you,
Yes.
you're going to pay capital gains between 20,000 and $600,000.
Those are powerful
And
moves.
a lot of people, like, it's catching a lot of people who are selling property right now. Nobody, the realtors are so fast to get them to sell that they don't tell people, go to your accountant and find out how much taxes you're going to have to pay.
Right. So I want to ask you too.
That's big.
Yeah, it is huge.
It really is. It really is.
Huh. And so, when you talk about, and I want to ask you, everything you said is just in a documentation, a form that you should fill out or things should be put in writing. Just wondering, with the millennials and many of us, would it be okay to videotape yourself, not have anything in written form, but to just simply state
it's not acceptable.
that would not hold up in court?
I know somebody that tried to do that. I was shocked when I found out that a lawyer even told him to do that, and the courts wouldn't even look at it.
Interesting.
You got to put it in writing, and it's got to be in writing in a legally acceptable way. Just to write it out, it has to not only be in writing, it has to be attested, meaning there has to be 2 signatures at least, and there has to be certain language that we call attestation, meaning that she signed in front of you, she asked you to sign,
right?
You signed in front of her and everybody else.
Okay.
And if you don't do it that way, the will's not going to be accepted.
Okay. And so that's why it's important to have a lawyer to actually double check
No,
those
do
documents.
it for you. No,
to do it. Prepare the documents for
just
you.
let us do it
and submit.
and let us do it. And actually, we just give them back. We give you the originals. I don't keep originals. I give you the originals, so you have your originals and a copy, because you never sign, you never mark on these documents either. They will invalidate them.
Interesting.
Yeah.
Okay, so I have a quick question.
All right.
For single women.
Yeah.
If you meet an amazing person, you decide to get married, and there's property that's been passed down to you through your family.
Yeah.
But you do not want to do a prenup, but you don't want your spouse to have access to the property or what's been given to you. How can you go around that without seeming dishonest? Maybe you just haven't gotten to the point of trusting this individual enough yet where you want to give them access to your family property.
Number 1, never put somebody's name on your deed that, let me say it in reverse. Once you put somebody's name on your deed, you cannot make them take it off.
Really?
Yes. Once you put somebody's name on your bank account, you cannot make them take it off. A lot of people don't realize that. Even husband and wife. I've had people come to me and they get a divorce. I had one lady, she put her husband's name on her bank account. He took $250,000 out of the bank account when they went into that she had borrowed on her house to save his property. They get a divorce, and the judge said, well, you put his name on the bank account.
So with deeds, once a name is added, it is permanent. You cannot
make the person on the, in very small, minute circumstances, in a divorce, a court might say they have to take their name off the deed. Usually they don't.
Interesting. Wow.
So you don't be, I tell ladies and men, as soon as you get married, you don't have to put somebody's name on your deed. People think you do. You do not. In fact, it's not advisable because you don't know if it's going to stick or not. Okay.
And so my next question too, in terms of spousal agreements, what are your
highly recommended?
And I know they vary.
Highly recommended.
Look, I know it varies from state to state.
I don't do them.
Okay.
But one of the my radio show's been on for 4.5 years. It started on February 14th.
Valentine's Day.
Yeah. Every year we do Law and Love.
Okay.
We do a series on Law and Love.
That's nice.
And
I like
there's
that.
a lawyer Michelle Thomas, who does prenups and stuff, and she comes on and she talks about why you need a prenup, and she's so good. She really is, you know. But in all seriousness, it is so important that you straighten out these things among yourselves.
Right.
Okay? It's so important that you have a lawyer who is going to sit down with you either by yourself or together and say, is this what you want? And then set it up that way.
Right.
You can always change your mind later.
Yeah.
Okay?
Okay.
But one of the most important things you can do with estate planning is in blended families. Not just when you're young and single, but also, my mother was married 3 times, bless her heart. Okay, and so the last one was 38 years. It was longer than the rest of them, you know?
Yeah.
And so I had to make sure and get that straight, because she had the 4 of us, and he had 3 too. And, you know, we love each other, but we knew it was going to be a fight.
Documentation,
You know what I
and
mean?
what
So
goes where.
just lay it out there and set it up, and it's good, you see?
And so, and then too, before we close out, I wanted to talk about, again, bouncing back to gentrification and how having a lack of wills, I think, has impacted our communities more than just
Hugely,
maybe economics. I think people are not realizing what
the
could have been done on our
and the
end.
delay involved in the probate process is huge, because if somebody dies without a will, you have to go through probate. Even if you have a will, you might still have to go through probate. I recommend, if you have a valuable asset, you know exactly what you want, do a trust. I know we haven't had time to get into that.
Let's get into it.
But, okay, real quick. A trust is an instrument that says, I own this, and I'm putting it in my trust. Okay, I can change it, but I own it. As long as I'm alive, it's strictly for me. But when I die, nobody else can change it. I appoint the successor, and I tell that successor what to do with what's in my trust.
Wow, so they're your appointee.
Your mother appoints you as her successor trustee. You must fund the trust, meaning you have to have a deed from your mother's house to herself as trustee of her trust.
Okay.
Okay, it's recorded. So now the house is in the trust. So when your mother dies, you are now the trustee. Her trust says, give my house to Crystal. You come to my office, we sit down, you as trustee does a deed to yourself individually, pursuant to the terms of the trust.
Okay.
And that's it.
That's it.
That's it. You don't have to go to court. You have to pay your mother's bills.
Absolutely.
But that's it.
Okay.
It's so much easier.
It is so much easier.
It's private. Nobody, will and everything else is totally public.
Okay.
Okay.
Oh, wills and
wills are public documents.
Public documents.
They're recorded. When you file your will
Right.
at the probate court, anybody can come and see.
Really?
That's how all the investors and speculators know somebody died at 1805 such and such
and
a
they're
street,
able to go in and
that's
purchase
it.
the
They're
property.
able to come and say, I want to buy this house. It's a public record.
But trusts are not.
They're not. They're
It's not public information.
Yeah.
And so you would recommend, well,
I
a
do.
case-by-case situation.
It really is case by case.
Right.
Okay. But let's get back to marriage.
Absolutely.
You cannot be a little married. You are either married or you're not, okay? So people say we've been separated for 30 years.
Right.
You're not divorced, you are still married.
Legally married.
And your spouse is the only person that does have certain marital rights that you cannot get rid of by will.
Okay.
Okay? You can say, I don't want my spouse to have anything,
Right.
okay? But they have a right. They have to assert it affirmatively, meaning that they have to come forward and take against the will. But they do have certain rights. It's important to know these things. It is. Now, they may not be able to get inherited property. That's a biggie. But I don't
For the
really,
most part,
you know, but it's better
what
to
you
have it
have.
in writing.
Yeah.
Okay?
And have this, and to be in love.
Honey, you got to have it in writing.
be in love,
whether
in
you're
writing.
in love or not, okay? Because
Like,
you can be
don't
in
be-
like. Don't get me started with that. But seriously,
Yeah.
it's not just among couples that it's important. It's among brothers and sisters.
Absolutely. Siblings. Absolutely.
There are a lot of people who inherit property, and they know that their parents intended for them to share it, but if they don't put it in writing,
Then it's up.
it
and-
gets sold and it's
yeah.
done.
Wow.
I've seen so many people get put out of their mama's house because there was nothing in writing. And
Right.
it's not just and you don't automatically say to everybody in equal shares. That may or may not work.
You have to just put it down
That
and
may
to
or
be
may not
clear
work.
about it.
Yeah.
And that's all the time that
Oh my
we
God,
have.
it's gone. Wow.
We have to bring you back.
Yeah, because there's a lot more
There's a
that I'd like
lot.
to share.
And thank you for sharing it.
Well, thank you for having me.
Wow.
Really, seriously.
Thank you.
Yeah. Thank you very much. Yes, yes.
Okay.
All right.
Well, that's all the time we have for today. Attorney Mitchell, again, thank you for joining us. And we'll see you next time on NDC Today.